What's up, everybody? It's your boy Uncut the Villain. We're pushing button podcast and news with the update news today. We got Young Thug in the news today. The judge is talking about letting him out. I don't know, but I ain't been following this case. But to me, I think this case was so full of shit. How the fuck you gonna get a RICO charge and you're a rich man? You want to gang bang when you're rich? You got to be a dumbass. So let's see what the judge got to say.
Mr. Bailey represented you all on of 2017. That was, you didn't have that particular certified copy of the arrest warrant, and so Mr. Steele by argument says, hey, look, I am extending my motion. I'm going to include everything that's in the house because you weren't validly in the correct space and place. Now, had you had that search warrant at that point in time, or not search warrant, but the arrest warrant valid at that point in time, then Judge Newkirk would have probably said, okay, well, then you're fine. But that wasn't that, these particular scenarios have to be ruled upon in terms of what the judge has at that point in time. So if you look at that, even if I accept, which I have, I've admitted, states 1, 2, and 3, you still have to return the man's property. He's asked for it to be returned. He hasn't had it returned pursuant to 17-5-30, because I can't go back and unring the bell in terms of Judge Newkirk's. You're not saying Judge Newkirk's ruling was erroneous, are you?
I'm saying that Judge Newkirk's finding was that we had not presented a certified copy of the arrest warrant, which is not the same as that there was an unlawful search and seizure. It's just that the state had not tendered.
On 3 April 2017, that's exactly what he was doing. Okay, so you're asking me at this point in time to say, hey, Judge, we can correct that. On December the 15th of 2022, you've introduced states 1, 2, and 3 certified copies of the arrest warrant, the return of search warrant and inventory, and the affidavit for search warrant. And that's why I'm telling you, assuming that that is now corrected, the problem that you still would have is the return of property under 17-5-30, because you took the marijuana and the other pieces of evidence from Mr. Williams' home. I don't think the law distinguishes between that. So you would have had to return that. You still would have to return the property to him. So, because at this point in time, he's entitled, or he would have been entitled, he's asked, and Mr. Steele has already introduced from in the last hearing on the 17th, he's asked me, or he's introduced a letter that he sent to Mr. Bailey saying, hey, I want the evidence back.
Your Honor, but the court did not rule that the state had to return that evidence, number one. There was no ruling as to that.
I disagree. I disagree with you. I disagree. By implication, Judge Newkirk had to have considered the fruit of the poisonous tree. Mr. Steele asked him to do that. And it's a snapshot in time. So on the 3rd of April, 2017, you didn't have what you have now. And so you're asking me to correct something that is arguably, can I do that? I mean, and even if I can, that still runs afoul of 17-5-30. You still would have had to return Mr. Williams' property. And then Mr. Steele asked you for the return of that property. And there's no exception under 17-5-30 pretrial that gives you the ability to keep the property. You have to return the property. The property that, and then you took that particular property, in particular his phone, and then you extricated things out of it, which would be tainted or fruit of the poisonous tree, because you didn't have the right to keep that. You didn't have the right to keep that particular evidence under 17-5-30.